Welcome back to Leading Edge. We're talking about the nation's highest court. The U.S. Supreme Court wrapped up its most recent term just last week. Lee Strang is professor of law at the University of Toledo's College of Law. We were talking about the many times these justices were actually able to find ways to agree on cases. But let's make sure there were certainly times when the justices didn't have their robed arms wrapped around each other singing Kumbaya. In California, it was legal for union organizers to go onto the grounds of an agribusiness to recruit workers. Two businesses cried foul. In the case of unions versus property rights, the court said what?
The Supreme Court, using the takings clause, said that when the government authorizes one private party, here a union, to enter into another private party's property without the owner's permission, that's a taking of the ability to exclude, which property owners in the American legal system have. And therefore, California, they can do it, but they got to pay just compensation, which of course would be a tremendous amount of money. And so the court continues its relatively broad interpretation of the takings clause as a way to protect private property owners' rights.
We're coming down the home stretch. Just last week, the court rules in favor of Arizona in a voting rights case. Detractors of this ruling said Arizona's voting provisions worked against minorities in violation of the Voting Rights Act dating back to the mid-1960s. Now, this was 6-3, and might say something about legal challenges to voting restrictions being enacted by Republican state legislatures around the country, or am I reaching too far, Lee?
No, so what you said is exactly right, Jerry, that in response to the last election and the perceptions of fraud and other misdoings in the election, legislatures, particularly those controlled by Republicans, are passing voter integrity legislation, Arizona being the example that was at issue in this case. And there are federal restrictions on the degree to which states can change their voting laws, in particular, how they impact racial minorities, given the history of oppression of especially Black Americans in the South regarding voting rights. And the Supreme Court relatively narrowly interpreted Section 2 of the Voting Rights Act. And that interpretation is consistent with the interpretation by the Roberts Court, which has been relatively narrow since Roberts was Chief Justice. So it's a clear conservative versus liberal decision in that case.
Brett Kavanaugh, rocky road to confirmation. We all recall watching that.
Wow.
Voted with the majority 97% of the time, more than anybody else, most of any justice. Is he now the new center or median of this court?
Yeah, I think that's right. So up until recently, the last couple of years, it was Chief Justice Roberts. And that allowed Chief Justice Roberts, who, as I said, he loves the Supreme Court, is an institutionalist, and loves to work within existing precedent. So he doesn't like overruling precedent because he thinks that Americans think the Supreme Court is a political institution when the court does that. And so that meant you had all these really factually intensive decisions, which were able to garner majorities on the Supreme Court. Justice Kavanaugh now is the median justice. I think most people view him as being slightly more conservative than Chief Justice Roberts. And that's going to play a big impact in the cases we're going to talk about coming up next term. But it actually played a big impact this last term. There were a lot of COVID-related religious liberty restriction cases. And Justice Kavanaugh, my perception was the leading justice for the conservative wing of the court. And he had a very strong conception of religious liberty. And so you had a number of 5-4 decisions with Chief Justice Roberts joining the liberals and Justice Kavanaugh writing for the conservatives. So it's his court right now.
Mentioned earlier, Justice Breyer, under some pressure from some quarters to resign and let Democrats pick his replacement while they still have a working majority in the Senate, the narrowest of margins. What are you hearing? What do you think?
Yeah, so what people on the left end of the spectrum are deathly afraid of is what happened with Justice Ginsburg. Justice Ginsburg had the opportunity to retire when President Obama was president and there was a Democrat-controlled Senate. She chose not to. There's speculation about what the reasons are, but the practical result was, as we all know, a Justice Amy Coney Barrett, which was a significant difference in the ideological valence on the Supreme Court. And so liberals are very worried about that. And my perception would be rightly so. I think Justice Breyer's perspective is that he's the leader of the liberal wing of the court. He's an articulate justice. He writes well. He writes persuasively, and that his view is that he has another year to be able to serve before a concern about losing the Senate and the ability to appoint a replacement would occur.
All right. Then we look forward to, well, first of all, we look forward to the rest of summer. Then, of course, we just look forward to that first Monday in October. You kind of alluded to a little foreshadowing from the professor here. Huge cases coming up in the fall. I mean, we get a Roe v. Wade challenge, I think, a concealed weapon case, among others. What has you looking forward with this court come fall?
Yeah, so there's I think the most important abortion-related decision since 1992, Casey versus Planned Parenthood. This case is called Dobbs versus Mississippi, and it involves a challenge to Mississippi's law, which practically prohibits abortion after 15 days. It targets abortions after the point at which, according to Mississippi's evidence, that unborn humans are able to both feel pain and perceive it as pain. And so that's the justification for that timeline. That's a significantly different justification than the current law. So under Casey and Roe, the current law is something called viability, the ability of unborn humans to live outside their mother's wombs. And that's typically at 20 weeks. It varies depending on the medical technology. And so the court has, I think, two choices. One is there enough of a majority, Justice Kavanaugh, as you mentioned earlier, to say, okay, we're going to continue to have a right to abortion, follow precedent, follow stare decisis, but move it back to 15 days. Heartbeat bill would be another kind of point of doing it. Or do we go all the way and overrule Roe and then return the issue to the states? And all eyes, I think, are on Justice Kavanaugh on that issue. Wow. And there's a lot of, as you can imagine, a lot of game playing out different snares and different arguments that might be influential or not to him.
And when it comes down, I'm going to be on the phone, texting, and asking you to walk us through all of it.
Sure,
you just make it understandable for those of us out here in the lay world. My thanks to law professor Lee Strang for keeping us on the leading edge of the scales of justice at the United States Supreme Court. And I'm going to be right back, going coast to coast on two wheels. This is Leading Edge.